You ever hear about a case so big, so potentially earth-shattering, that if Supreme Court actually ruled the right way, it would single-handedly wipe out every so-called assault weapon ban in the country? Yeah, that case exists. And it's sitting right there, waiting for the Supreme Court to pick it up. This case is called Snope v. Bruen, and if you believe in the Second Amendment, this is the one case that could change everything. The Supreme Court has the opportunity to take up this case and strike down every unconstitutional state ban on semi-automatic rifles in one fell swoop. And make no mistake, this case is not just about Maryland. It's about California, it's about New York, it's about every state that thinks it can just ignore the Second Amendment. So today, we're gonna break down what Snope versus Bruen is, why it matters, and how it could be the case that finally forces these anti-gun states to get in line with the Constitution. You see, for decades, these anti-gun politicians have been playing a game. Every time they lose at the federal level, they take the fight to the states. They couldn't get the federal assault weapons ban reinstated, so what did they do? They started banning semi-automatic rifles state by state. Maryland, New York, California, Illinois. They use different names: assault weapons ban, gun safety laws. We swear we love the Second Amendment, but not really acts. But at the end of the day, it's all the same thing: a blatant infringement on your right to bear arms. And here's the problem. While we've been winning huge victories at the Supreme Court, Heller, McDonald, Bruen, these states have just been flat out ignoring those rulings. They've been getting away with it because lower courts, stacked with anti-gun judges, keep rubber stamping their bans. That's where the Snope case comes in. Back in 2013, Maryland passed a law called the Firearms Safety Act. Sounds harmless, right? But we all know it's not. This law banned a whole list of semi-automatic rifles, including the AR-15, making it illegal to buy, sell, or transfer them in the state. David Snope, a Maryland resident, wasn't having it. He sued the state, arguing that Maryland's law violates the Second Amendment because those are some of the most common firearms in America used for self-defense, hunting, and sport shooting. He lost at the district court level. He lost at the appeals court level. Why? Because the Fourth Circuit, like a lot of these blue state courts, completely ignored the Supreme Court's decision in Heller and Bruen and basically said, yeah, we don't care. So now, Snope's lawyers have taken the case to the highest court in the land, hoping the Supreme Court will finally step in and settle this once and for all. So why is this case such a big deal? It's simple, really. The argument for upholding Maryland's ban is based on a legal theory that directly contradicts Heller and Bruen. Let's go straight to the brief. The Second Amendment protects arms that are in common use for lawful purposes. The AR-15 and similar rifles are among the most commonly owned firearms in the country, making them indisputably protected under the Second Amendment. That's straight out of Heller. The Supreme Court has already ruled that firearms in common use cannot be banned. And what do the anti-gunners always tell us? You don't need an AR-15 for self-defense. Cool story. That doesn't matter. The Supreme Court already decided that's not how this works. If the Supreme Court takes this case and rules the way they should, every single state level ban on semi-auto rifles could be wiped out overnight. Because if Maryland's ban falls, every other state that has a similar law would be violating the exact same Second Amendment protections. And just so you don't think I'm making this up, let's roll this news clip real quick.
The U.S. Supreme Court is letting Maryland's ban on assault weapons stand for now. Justices declined to hear a challenge to the state's law banning 45 specific firearms. The ban includes the AR-15 and copycat weapons. Some semi-automatic handguns and rifles are still allowed. The case is likely to end up back at the Supreme Court once that decision is made.
So there you have it. Even the mainstream media is acknowledging that this case has the potential to go all the way back to the Supreme Court. Now, of course, Maryland is trying to weasel its way out of this. They're arguing that semi-automatic rifles are military-style weapons and therefore not protected. But here's the thing, that's not how the Second Amendment works. Let's go back to the brief again. The AR-15 is functionally no different from any other semi-automatic rifle, many of which are not banned under Maryland's law. The state's distinction is arbitrary and inconsistent with the Second Amendment. The government's argument is basically that AR-15s look scary, but functionally, they're no different from any other semi-automatic rifle that Maryland hasn't banned. So the ban isn't about function, it's about optics. And that's the problem. Anti-gun states are trying to justify unconstitutional laws with emotional arguments instead of actual legal reasoning. They know they can't win if they follow Heller and Bruen, so they're trying to redefine the Second Amendment on their own terms. This case has the potential to be the most significant two-way ruling in history. I want you to realize if the Supreme Court takes it, we could be looking at the complete collapse of state-level assault weapons bans. Now, with all this talk of assault weapons, which are just semi-automatic rifles, they're not actually assault weapons, but whatever. You know, rifles, AR-15 specifically, can be incredibly loud. And I think sometimes people underestimate just how loud these things really are and how damaging they can be to your hearing. If you're not wearing the correct hearing protection, you are subjecting your hearing to absolute brutal damage. Which is why I guard my hearing as best as I possibly can. And one of the ways I do that is with my favorite wireless Bluetooth in-ear hearing protection, the AKT-1s. I love these things for a number of reasons. One of them being that it still gives me the situational awareness of what's going on around me because it has active noise blocking. And it has the passive hearing that allows me to hear what's going on while blocking the dangerous noise levels that happen when you're at a gun range. It also allows me to listen to music and take phone calls while I'm at the range shooting. Now, generally speaking, when I'm outdoors, I only use one pair of hearing protection. That's usually in-ear, like these AKT-1 blackouts. They have a 25 NRR decibel rating, which will serve you just fine when you're shooting outside. However, when I'm indoors, because of the reverberation you get from the walls when you're shooting semi-automatic rifles like the AR-15, I double up. Not only do I use the in-ear AKT-1 blackouts, but I also use the over-the-ear AKT-1 hearing protection as well, which gives me up to a 30 NRR rating. That might not sound like much, but the way decibel ratings work, going from 25 to 30 is a big deal. So when I'm indoors, I double up. When I'm outdoors, I wear my AKT-1 blackouts. So keep that in mind when you go to the range. If you're gonna be inside shooting AR-15s, double up. If you're gonna be outdoors, you can get away with just these in-ear wireless Bluetooth AKT-1 blackouts. But if you really want the ultimate experience, click the link in the description section of this video and grab both of them today. Trust me, your next range day will be a whole new experience. Now, this case has the potential to be the most significant two-way ruling in history if the Supreme Court takes it. We could be looking at the complete collapse of state-level assault weapons bans. So like, comment, and subscribe to the channel. Let me know in the comments if you think the Supreme Court will take this case.